Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Yeah, shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's true with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Yeah, shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
All caps means you're either panicking or trying to represent yourself in court. Both are mistakes. Your feelings are adorable, but they're not admissible, persuasive, or even interesting without evidence. Yes, Heather hates immunity doctrines. It's a personality trait at this point. You don't need to remind her, she wakes up angry about it. Bring receipts. No, I heard it from so and so. This is quid pro quo, not next door. Screenshots are statutes only. Don't fight each other. Fight the law. It deserves it more. If you're offended, excellent. That means you're awake, paying attention, and probably new here. No diagnosing the host. She's petty, not pathological. And don't diagnose anyone else. Stay in your lane, please and thank you. Do not summon the mods. They're tired, hangry, and may bite when provoked. Disagree loudly if you must. The algorithm eats drama for breakfast. Just keep it cute while you argue wrongfully. If you're taking screenshots of my chat, touch grass, tell your handlers. I said hi and find a hobby that isn't me.
Hey guys, welcome to the redirect. This stream was set up for tomorrow, but we changed our mind because the Nikki Stein's hearing in Kentucky was very anticlimactic, and instead of being 5 to 10 minutes with a discussion on either side about what it could be, what it could mean, what's next, what we could look forward to, we got muted, and then we'll discuss that further at a later date, and a sidebar about a change of venue motion, and that's it. It was like a minute and a half. We sat there staring at the screen longer than the actual hearing. So on that note, since it was less than a half an hour stream, we just redirected over here so we can talk about Hannah Dugan in Milwaukee, the affectionately known as the rogue judge, the backdoor judge. I just hate using the word rogue. It just annoys me. but I appreciate everybody joining me over here for this stream. This will take a little bit longer. She has filed a 22-page motion for acquittal. And we all know, if you've ever watched a trial before, when the prosecution is done putting on their state or on their case, the defense pretty much always files a motion for acquittal. It's kind of a procedural thing at this point. You beg and plead and say how the state didn't put on, or the federal government in this case didn't put on their case. However, this is the first time that I've actually gotten my hands on a copy of one, especially a federal one, and it's 22 pages. It was filed yesterday, and we are going to get into it. For those of you who are just joining this stream and did not see the last one, the little 25-minute, half an hour thing we just did, I did purchase the transcripts for these, the first part of this trial, including the defense's opening statements. So if they cost me $75. So if y'all ever want to send any of that like Starbucks money, or if y'all got some like Lululemon money, if you know, you know, and if you are ever feeling so generous, please help a girl out, because I do this for you, but these documents are not cheap. They're not cheap. $75 for those documents. So we shall see. But Unhung Hero, thanks for getting us started with 10 gifted Squid Pro Quo memberships. I appreciate you so very, very much. We should probably do a members only chill and chat Friday evening, probably around 6:30 or 7. We shall see what happens. It's kind of, everything is kind of crazy this week. I still haven't finished the video for the other channel. I am behind as hell on that. But we shall see who got those memberships. All right. And it's a bunch of good people. And then Unhung Hero, I'm not a professional backdoor judge, but I'll take a look. Jesus. Oh, you need Jesus. And Linda Taz, thanks for the $5 super chat to help start the stream off today. Hugs. Thank you. Starting the stream off on a good note. I love you guys. I couldn't do this without you guys. $74.80. So yeah. But it was funny. It was very like, I know those hearings are generally short, so it wasn't going to be a very long stream. But like that was, huh? Huh? All right, but getting into this. Document reading. There we go. Hey, Jeannie, how are you? It's going. It's busy. It's super busy. I hope you are doing all right. Defendant's motion for judgment of acquittal. I doubt this will get approved. There wasn't an order in yesterday, so we'll see. Hannah Dugan now moves for judgment of acquittal on both counts of the indictment, pursuant to Rule 29 of the Federal Rules of Criminal Procedure. She does not submit a separate brief, but offers authority and argument here. Evidence. Most generously to the government, the evidence stands now as follows. On Friday, April 18th, ICE agents and other federal agents had an administrative warrant for EFR's arrest and removal from the country. If you don't know, he has been removed from the country. Yeah, it's the top news here in Milwaukee. Hey. No. You cannot have that. No, it's not yours. It's mine. I can only imagine what the courthouse is like downtown. Thank God I don't have to go there. And hey, Paul. He had a pending misdemeanor case assigned to Judge Dugan's branch. They don't seem to mention that it was a DV case. I was trying to figure out a way to put that lightly. I just can't. I just can't. Um, hey John, how are you? OUV, Alabama, mm, Oklahoma. Ok and Taz, thank you for the $20 super chat to help you out, hon. I appreciate that. How'd you get away with that? Toddler real estate, what's mine is mine and what's yours is mine. I have Built Bars in my like Built Bar Puffs, and she had one earlier today. It's like a protein bar, but it's marshmallow and it's chewy and she can't chew it. So it ended up just being left on she put it on the floor and I'm like, so I refused to give her a second one because she's not going to eat it. And those aren't like granola bars. They're twice the price. So I'm like, if you're not going to eat it, I know you're not going to eat it. It's going to get thrown away. But now her dad is home. So she probably took it to him and tried to get him to open it. So see, you're the best. I wouldn't get it. I blinked and I missed the last hearing. Yes, you did. Yes, you did. He had a pending misdemeanor case adjudged to Judge Dugan's branch. 2 judges in robes, Dugan and Severa, approached the agents in the hallway outside Judge Dugan's courtroom. Dugan directed them to talk with the chief judge, whose offices were down the hall. While some agents were in the judge's office, the 2 remained in the public hallway outside her courtroom. Dugan went back to the courtroom, interrupted another defendant's brief hearing, and directed EFR and his lawyer to step forward. EFR spoke only Spanish, and no Spanish interpreter then was available. Judge Dugan and her staff called EFR's case off the record. This to me is a major problem, right from the get-go. Nothing in a courtroom should be off the record. Nothing. Nothing. And gave him a new date. She told EFR's counsel that he could appear by Zoom and that at the next date if he wished. Then Judge Dugan ushered EFR out a door near the bench in the courtroom with his lawyer. Court staff use that door, and lawyers sometimes do, but parties and witnesses do not. Although a jury could find that she said something about the stairs and taking the heat moments earlier as she spoke to court staff, on the undisputed evidence, Judge Dugan, in fact, pointed EFR and his lawyer to the right down the corridor that ran parallel to the courtroom and opened into the public hallway under 12 feet from the public doors. And we had this conversation last time. Just because you were bad at being a criminal does not make you any less of a criminal. As viewed from the public hallway, she did not point him and his lawyer to the left where the stairwells were. Judge Dugan then returned to the bench and continued with the rest of her docket. She did nothing more that morning that is relevant to these charges. Yeah, but that's not the point. The deflection. So it's always the deflection. Well, I didn't do anything else. It's not the point. You fail to understand the point. EFR, in fact, emerged into the public hallway 12 feet to the right of the public doors to Judge Dugan's courtroom. 2 undercover federal agents in the public hallway saw him emerge into that hallway. One of the agents, Brian Ayers, testified that he did not even know that EFR had used a separate door into the public hallway until reviewing video later. Also not the point. Also not the point. Also not the point. I don't know. This is where it's like, I was only speeding a little, not the point. If you get pulled over for speeding and you were in fact speeding, it doesn't matter if you were going 2 over or 20 over. You were in fact, by definition, speeding. The deflection. It's the deflection. Another motion denied. Yeah. I'm not sure yet. There was no motion there when I went, but it might have been a verbal order too in court this morning. We shall see. Oh, and to the person who just emailed me, you are awesome. and I will read it more fully later. But hold on. Yeah, Fletcher boy, a little bit pregnant. Yes. Like, there's a lot of these questions there's not a little bit. You either are or you aren't. Just have to respond quick to this. Why isn't my phone charging? Well, there's another problem. You're retiring soon? Congratulations. It's after texting with other agents getting instructions, one followed EFR onto the elevator down to the lobby. Once he left the courthouse, agents arrested EFR outside after a brief foot chase. I mean, I guess that's how you're a little bit pregnant. I mean, the government offered no evidence that Judge Dugan acted corruptly in either the ordinary sense of the term's common usage or as courts have defined this motive element of 18 U.S. Code 1505, the statute charged in count 2. They're so focused on every motion they filed. They are so focused on this charge. The government tendered no evidence of bribery, other graft, or form of actual attempted self-dealing by Judge Dugan. No, she thought she was above the law. There's the thing. She thought her morals, these are people, no matter what you think of our immigration system right now, because it takes people forever to do it legally, which is one of the reasons that a lot of people come here illegally, is because our shit is broken. However, instead of fixing what is broken, people just decide not to enforce any laws at all. And these are the people that try to tell you that their morals are better than yours. They try to stand on this moral high ground and tell you that you are this awful person because you want to enforce laws. That is the personality that Judge Dugan has. It has nothing to do with she didn't do anything corruptly. No, she thinks she's better than everybody else. And she thinks she can do things. In other news, Morgan's not going to contest the petition for conditional release. Yeah, Jeannie, you and I have to talk about that case. Jeannie is from Milwaukee and lives in Milwaukee right now and has an inside track on a lot of the Morgan Geyser stuff. I haven't touched that case since I used to work out and go to the gym with the teacher of the victim at the time. So it's weird, but we have body cam footage and shit that we still haven't gone over. I'll pass on the twins. Agents never gave Judge Dugan EFR's name or identified him to her. Yeah, but she knew, and that's the point. She knew and did it anyway. That's the point. Instead of letting law enforcement just do their jobs, it's not that hard. There's two things that are free in life: the ability to mind your own damn business and stay in your own damn lane. This was not her lane to get into. She went into somebody else's lane and got smacked back into her own with some charges. And now she's mad. That one, nobody's been served yet. So, yeah, do you know who I am? Exactly. They also never showed her the administrative warrant. You never asked for it. They don't. She acts like she runs the damn. Yes, you run your courtroom, ma'am, but they never stepped foot inside your courtroom. So, Oh, yeah. Yes, drive safe, and if you drive past my county, wave as you drive by. I'll feel the disturbance in the force. Judge Cervera, though, testified that Judge Dugan said the name Flores. When another judge testifies against you, that doesn't look good. Honesty isn't in her vocabulary. She literally went into another judge's chambers and had to go out in the hall with her to confront ICE. Her words, not mine. Yeah. Yeah. The agents saw EFR when he re-entered the hallway and they followed him. They arrested him outside the courthouse. It's not the point. Just because you're a bad criminal doesn't make you any less of a criminal. Like that. I I mean, that they have a TV show, or they used to have a TV show called World's Worst Criminals or World's Dumbest Criminals. Being an intelligent and being good at breaking the law doesn't, just because you're really stupid and really bad at breaking the law, does not mean that you're any less of a criminal. Like, I just don't know how to describe that any other way, and it just kind of things that make you cringe. It's the equivalent of, "Do you know who my dad is?" Don't care. The government's implicit suggestion through its evidence that EFR finished his court appearance and walked into a public hallway too quickly, not too slowly, that morning, because Judge Dugan called his case almost immediately after returning to the courtroom. Off the record. I have you off the record. Oh my goodness. Oh. Thanks, Jeffrey. If during the last stream, I had commented that the documents were still locked, but I guess now they're not. So we'll get through this, and depending on what time it is, we might do that too. Who knows? Maybe the punishment should be worse if you committed the crime and were incompetent about it. I don't know. But we'll try to get through these 22 pages and see where we end up. On any view of this evidence, though EFR returned to the public hallway at exactly the same time he would have had left the courtroom through the usual doors, he just took a different path straight into the public hallway. On the route he took, he was no more concealed from the agents who were not in the courtroom and could not see what was happening there. Then he had instead walked back to the courtroom gallery to the usual doors. We went over this. It's it's one of those situations where, like, just because you didn't conceal him well doesn't mean you didn't try. So, argument count 1, no crime because no concealment. My argument back, just because you're a shitty criminal doesn't make you any less of a criminal. The undisputed evidence here is EFR and his lawyer used a non-public corridor. Yeah, a non-public corridor that you let him go through because you know that there was ICE agents in the hallway waiting for him. That common sense tells you that you were trying to conceal him. You just didn't do a very good job at it because you suck. Further, there's no dispute that undercover agents saw EFR emerge into the public hallway. Like, one agent to his left and one to his right, exactly as they would have been if EFR used the main doors less than 12 feet to his right. Stop mentioning the 12 feet. Less than 12 feet. Doesn't matter. It, like, once again, just because you're a crappy criminal does not make you any less of a criminal. Again, the undisputed evidence, no agent was in the courtroom. No agent was able to see in the courtroom from their respective locations, which is why you tried to put him out the side door so that they couldn't see him. You didn't think ahead because you're not that smart. God, lawyers really aren't that smart. Like, no offense to any lawyer who is smart. Y'all have a very high degree and y'all are pretty some dumb motherfuckers. Sorry about my language, but like, Exhibit A, Florida. Y'all are some dumbass motherfuckers. You have some very high book smart, and your common sense and ethics just leave room for much improvement. Much improvement. Like, either way, they could not see EFR in the courtroom or the non-public corridor, but could see him immediately when he re-entered the public hallway. And maybe she expected, because if you left that door, you go to the right, you go back into the public hallway, you go to the left, and there's a stairwell. My belief is that she expected them to go to the left and take the stairs, and they didn't. So just because your criminal is really also your criminal that's in your courtroom is also really bad at being a criminal. 2 really bad criminals equal a federal prosecution and a deportation. Just saying. Hey, Hill on top. Yeah, no fixing, stupid. And Tammy, how are you? Good to see you. It's the way their brains work. My brain doesn't work half the time, and I still claim I have more common sense than some of these motherfuckers. You can be very well educated and also really stupid. Yeah, see doctors. Some are great, and others are like, how the fuck did you graduate? Engineers, same way. Very large intelligence. A friend of mine who I will text him and be like, some of you people are dumb. Yep, they already deported this guy. So they saw him at the same time with a difference of under 12 feet. They keep mentioning this 12 feet like it matters. It doesn't matter. It's the act, not the result. And she's trying to argue the result, and the government is arguing the act. And I think that's a lot of differences that I see when I'm talking to someone and we have disagreements, is we're arguing fundamentally a different topic. Someone will be arguing the result of something, whereas I will be arguing the basic, like the actual act, not what happened because of the act, but the process. On those undisputed facts, drawing all reasonable inferences in the government's favor, Judge Dugan did nothing at all to conceal EFR. No, you tried to conceal EFR, you just sucked at it because you're a bad criminal, because you're stupid. And we've gone through a lot of this stuff before, so we're going to kind of just skip to what's important here. No crime, because executing an administrative warrant in a courthouse would violate longstanding common law privilege. Federal and state courts have long recognized a common law privilege that presents civil arrest or service of civil process as to parties and witnesses who are in or coming to or going from a courthouse for a hearing or other proceeding in a courthouse. Whole bunch of case law. There's whole bunch more case law, citing both federal and state cases, including but not limited to Wisconsin cases. An 1894 Wisconsin Supreme Court decision describes well both Wisconsin law on this privilege and the common law privilege more generally. It involved a judge who was served civil process in the courthouse. Oh my God, see, I have problems with this case law. You cite case law, but your case law, just from reading what the case is not applicable. It involved a judge who was served civil process in the courthouse. One, you're not serving a judge, you're serving a person you're not serving an employee of the courthouse. There's a difference. Sorry, I have a very big issue with lawyers when they try to spin facts, and that's one of the things that their job is to do, but the service should have been set aside, the service of process upon a justice while holding court upon a party and witness in attendance upon and in the presence of was a contempt of court. Stupid. It has long been settled that parties and witnesses attending in good faith any legal tribunal are privileged from arrest on civil process during their attendance. Well, he was done with his attendance. They didn't go in during his hearing and arrest him. They waited till he was done. He's also not a judge or an employee of the courthouse. He was a defendant. Also a difference. I'm ripping this bitch apart. I hate this chick. Just her little smug ass face. Ugh. She thinks she sits on this moral high ground, and it's like, no, you have no morals at all. Yes, this smells of desperation. You stink. You smell like desperation. The privilege extends to the service of a summons as well as to arrest. The reason for the rules are manifest. No court should be subject to such interruptions. They didn't interrupt. That's the point. You went out in the hallway. Another thing, she went out in the hallway to talk to the ICE agents. The ICE agents did not enter her courtroom. Oh, sweet baby dumpster Jesus. This chick, man. And I keep calling her this chick because that's the most appropriate thing that I can think of right now to say that won't get me yeeted off YouTube. Parties necessarily in attendance upon court should be free to attend their duties without disturbance or fear of it. The rule is made to subserve the best interests of the public and the due and speedy administration of justice, order reversed and cause remanded with directions to grant the motion. While some of the Wisconsin cases and some others extend the privilege only to non-residents, that helps the government not at all here. Its whole underlying point is that EFR was a non-resident and unwelcome one, both of the state and of the whole country. Sometimes you read shit, does it just want to make you like beat your head against a wall and be like, I can't believe someone was stupid enough. This is like a Bruce motion. Like this has bubbles written all over it. Immigration generally and removal proceedings specifically are civil, of course, not criminal. Okay. Noting to that no bail provision of immigration statutes is civil detention. The process occurs in administrative courts under civil burdens and of persuasion. The goal of removal is deporting an alien, not incarcerating or punishing him. Hence the administrative warrant. Yeah. This is another reason why I believe this whole courthouse is like this. This is the problem with Milwaukee County. See ya. Oh. As the Supreme Court explained at length in Stewart v. Ramsey, both it and other courts have repeated since, the true rule founded in reason and sustained by the greater weight of authority is that suitors as well as witnesses coming from another state or jurisdiction are exempt from the service of civil process while in attendance upon court and a reasonable time coming in and going. I don't agree with this, but that's probably the best case law and phrasing that they've used in this entire motion so far. And we're on page 7. Courts of justice ought everywhere to be an open, accessible, free from interruption, and to cast a perfect protection around every man who necessarily approaches them. The citizen in every claim of right which he exhibits and every defense which he is obliged to make should be permitted to approach them, not only with subjecting himself to evil, but even free from the fear of molestation or hindrance. He should also be enabled to procure without difficulty the attendance of all such persons as are necessary to manifest his rights. Now this great object in the administration of justice would in a variety of ways be obstructed if parties and witnesses were liable to be served with process while actually attending the court. It is often a matter of great importance to the citizen to prevent the institution and prosecution of a suit in any court at a distance from his home and his means of defense, and the fear of a suit may be commenced there by summons, will as effectually prevent his approach as if a capious civil arrest warrant might be served upon him. This is especially the case with citizens of neighboring states to whom the power which the court possesses of compelling attendance cannot reach. Oh, yeah. The court went on to elaborate that the privilege which is asserted here is privilege of the court rather than the defendant. It's founded in the necessities of judicial administration, which would often be often embarrassed and sometimes interrupted if the suitor might be vexed with the process while attending upon the court for the protection of his rights. It wasn't in your courtroom. That's another problem. Like, just imagine an ICE. Yeah, I know, right? Witnesses would be wary of coming within our jurisdiction, would be exposed to dangerous influences, blah, blah, blah. This is not judicial immunity. It's not a privilege of the party or witnesses directly or exclusively. Oh, yeah. It's more of it's more of the same BS. Like, hey, Squawab, how are you? Gifted 1 Squid Pro Quo membership. Thank you so much for that. Even more importantly, immigration statutes do not abrogate this privilege as to administrative warrants or notices that ICE, CBP, or other federal agents involved in the civil process or removal of deportation may serve. Oh, more case law. Relying on only this privilege under New York law and declining to decide whether federal law provides a similar privilege. Judicial warrants for criminal cases are different. Okay? But all are agreed here that these agents only had an administrative warrant, not a judicial one. Who's back? Hannah Dugan. She's a Milwaukee Circuit Court judge that is currently on federal trial in Milwaukee County in the Eastern District of Wisconsin for allowing a illegal immigrant to leave out the side door. So, yeah. Here, then EFR was a non-resident. He had a court appearance in Milwaukee County Courthouse April 18th. At least on the outside of that morning, federal agents sought to arrest him in the courthouse. Sorry, bitch. Sorry, bitch. You had said in a previous motion that they planned to arrest him outside, that they should have never been in the courthouse because they had always planned to arrest him outside. Here, you're saying federal agents sought to arrest him in the courthouse. You can't have it both ways. I will go back and find that motion where her lawyer had stated that, but you can't have it both ways. You can't use it as an excuse if she did nothing wrong because they planned to arrest him outside, and you put this in your motion for acquittal that they planned to arrest him in the courthouse. You literally can't have it both ways. I don't. Oh, yay. Walks in, reminds people of the court order, smiles and sits down in soft seats. Oh, yee. Backseat for you. Hong Hero, thanks for the $2 super chat. Leave it to a backdoor judge to be. After the hearing in his misdemeanor case, his misdemeanor DV case, if we, want to get specific, they only had an administrative warrant. I'm trying to clutch my proverbial pearls. And removal is a civil process, not a criminal one. EFR had no pending or contemplated federal criminal case. All of this is undisputed. She acts like that matters. Sorry, even though it's civil, technically, you still broke a statute and a law coming into this country illegally. Sorry, I hate to break it to you. Illegal is illegal. Oh, yeah. And it means that Judge Dugan did nothing in the courthouse that day that had legal effect on concealing or harboring EFR, contrary to 18 U.S. Code 1071, the statute at issue in count 1. He simply was out of reach of the federal agents on that day, in that place, with the civil arrest warrant they possessed. He had a long-standing privilege under both federal and Wisconsin law to come and go freely. As a matter of law, then Judge Dugan's acts in that day in the courthouse did not conceal or harbor EFR. Once again, just because you're a shitty criminal doesn't mean you're any less of a criminal. No crime because no materiality. Judge Dugan disagrees with the court's conclusion that materiality is not an essential element of 1071. Immaterial concealment or hindering logically is no concealment or hindrance at all. Certainly when someone's liberty and reputation is at stake on criminal charge. Oh, the mental gymnastics that this lawyer had to do to write this. Simone Biles worthy, Olympic gold medal, but not logical and quite frankly giving me a headache. It's not illegal if you immediately file an adjustment of status, right, lawyers? Wink, wink, nudge, nudge. Even in the civil setting of patent infringement, a defendant must sell or supply a component that forms significant part of a plaintiff's invention. With the advisory committee explaining that significant effectively is the definition of materiality. Likewise, in the setting of employment discrimination, a plaintiff must prove that an adverse employment action was material. She goes into employment law. I could care less, and I'm been listening while I was in the truck, kind of chuckled about even a small, crappy criminal is no less a criminal. I mean, where's the lie? Like, speeding is a great example. Whether people get pissed off because a cop pulls them over when they were doing 3 miles over the speed limit. 3 miles over the speed limit is still speeding. Technically, you're still breaking the law. You might not have been breaking the law a lot, but you were still breaking the law. So if you get pulled over, no, she's not pro se. She has a legal team. Her legal team just is, I don't know. Her legal team just makes me want to beat my head up against a wall because the mental gymnastics. Apart from an express requirement of materiality, though the government's evidence fails, even if the court's chosen instruction, Judge Dugan's acts did not actually conceal EFR, as count 1 requires. Just because you sucked at concealing him doesn't mean you didn't try. It's not the end result. It's the act. You attempted to. It's like my toddler. I can try to hide her under a blanket, but she wiggles her way out because she's 3 and she just wiggles and never, she's under the blanket. Just because I sucked at hiding her doesn't mean I didn't try. Be prepared to be frustrated, Calvin. Just be prepared. As Judge Dugan notes above, that is unavoidably true because EFR no more was concealed from federal agents while he was invisible to them inside the non-public corridor than he would have been for the same time and did not the same distance travel into the public courtroom itself. Agents were not in the courtroom and they were not looking into the courtroom. It's just, Hero, thanks for the $5 super chat. If you're going to speed, do it like me. Make it count. 105 and a 70. Well, driving through Chicago, I try to get through there as fast as possible. And if you you just gotta do what you gotta do. I'm probably already. Just got back from the VA. Oh, good Lord. Good luck with that. These people do not think illegal aliens with nothing to say. You can be here. They're right. The law is wrong. And these are the judges and the people who are on social media and all that think they sit on a moral high ground because they have more money than you, or they have a better education than you, or this. They sit on this moral high ground and tell you that you are wrong or you're a bad person. And it's like, that's not how this shit works. Oh, I know. I heard a Cessna. Let's see. There was no actual concealment, as the court agrees this count requires. No crime. No crime because Judge Dugan had a legal right to do everything she did. Finally, Judge Dugan reiterates and relies on her earlier arguments that she may not be prosecuted in federal court for official acts that her state employment authorized her to do. She will not belabor that point here. Oh, yes, yes. Official acts allow you to go and confront federal agents when you are not a federal employee. Mm, mm. uh, if I had to spend time in that courthouse, I wouldn't want people there with pew pews and masks. But this is a really stupid filing. Yeah. I mean, but at the same time, Annie um, the bailiffs all have weapons, so having federal agents there with weapon is not really that different either. And in order to get through the courthouse, you have to tell people who you are and you have to show badges and in order to bring that stuff in the courthouse because you go through metal detectors. So it's not like you're just letting, Joe Schmo off the street walk in with a weapon. It's there's that, you know, and state law doesn't trump federal law. Yeah. It eh. Rather, she adds, only this, the government's actual evidence in part is clarified on cross, shows unequivocally that the 5 acts that the indictment alleges ranged from very common to not unprecedented to unremarkable. Many misdemeanor status appearances get called off the record, and that to me is a problem. Like that right there is a fucking problem. Lawyers often use the door that judges directed the assistant to. The assistant state public defender and her client used here in returning to the public hallway. Appearances by Zoom have been common since the COVID pandemic, and sign on the courtroom door here even invited members of the public and lawyers to request them. It's not what she did, it's the why. She only did it because, and she hid behind, well, it's an official act. And the fact if you have to file a motion and you hide behind judicial immunity, you know you didn't do something right. Like, yeah, if she would have just kept him in there, like, yeah, but Annie, in order to get in the building, they had to show ID and go through metal detectors. So the whole courthouse knew that they were there. So it's a little different than the random person off the street bringing in a weapon. It is a federal agent with a badge. I see your point, but I disagree with you in the sense of in order to get into a courthouse, you have to go through metal detectors. And if you do bring a weapon in, you have to have a reason and a badge generally. So it's, I see your point. However, and I don't think they were wearing masks in the video. I think they had them like around their necks, but they weren't wearing them. So remember, these are federal agents. These are not just Joe Schmo off the street with a concealed carry license. So ladies, watch out. Snipe hunters here. Yeah. Like, hey Heidi. Thank you so much for doing your modly stuff. And Roy and Gail also, thank you so much. Ugh. A judge talking with people in the hallway, especially if they present a risk of disruption, is not unprecedented. Yeah. It's not, and also, I don't think it's one of these situations. It's it's all of them combined. It's the going out in the hallway, it's the side door, it's the Zoom, it's off the record, it's all of them combined adding up into the situation. 1 or 2 of these, probably not, but all of them combined is just shut up, Bobby. Like, oh my god. Mm-mm. Ugh. Alright. In short, everything Judge Dugan fell well within her state judicial powers. Count 2, no crime because the government offered no evidence or corrupt, even wrongful motive. The government proposed jury instruction defines that corruptly in element 1505 only as wrongfully or wrongful. The court preliminarily has suggested it will accede to the government's proposal, while the Seventh Circuit has concluded that a similar instruction was not error, it was adequate, has gone no further. It is said that this was the only way or the best way to explain corruptly element to a jury. Yeah, this is what I like. I don't think this is a good. I don't think this is good for her. This instruction is not for two reasons. First term wrongfully reduces this element very nearly to the whole crime itself, to a tautology. Because it is wrongful to commit any crime, a jury might conclude that doing so in the acts of 1505 is inherently wrong and therefore satisfies this mental element of the offense. Oh, yeah. It's just, like, corruptly rightly requires a defendant to intend to procure an unlawful benefit for herself or for someone else. That is the better instruction on the meaning of corruptly. This should have been in your proposed jury instructions then and not in a motion for acquittal. I just... She's going back and forth on the definitions between corruptly and wrongly. Like, however, the court defines corruptly, though, as the government's evidence falls short. There's no evidence that Judge Dugan acted corruptly in the ordinary sense or in the way the Seventh Circuit explained the term in Edwards, let alone in the more accurate way that Chief Justice Roberts approved in Fisher. At very worst, this jury could infer the evidence here that Dugan disagreed with ICE's enforcement tactics in state courthouses, as opposed to say that she was trying to understand and comply with a tentative courthouse policy that the chief judge has not yet issued in final form. Oh, the mental gymnastics. There's no evidence she acted corruptly here or even wrongfully. Her 5 acts, like things like calling off case off the record, inviting the defendant to appear by Zoom, and choosing which courtroom door he would use to re-enter the public hallway were mundane and well within the scope of her official duties and prerogatives as a state judge. Take it from an everyday person's perspective. If you or I tried to help an illegal evade ICE, would we be arrested? Most likely. I would say a 99.9% chance. Like, she had every right to do that. No act the government's case in chief arguably proved in the light most favorable to the prosecution fell outside of her state judicial powers. Once more, what a defendant has a right to do does not violate 18 U.S. Code 1505, the statute at issue in count 2, or logically of any other obstruction offenses. No crime because no endeavor. The government's case includes a courtroom audio recordings that, viewed in the light most favorable to the government, would allow jurors to reasonably to conclude that Judge Dugan made a reference to the stairs. Didn't that? And that she said that she would take the heat. But all that was indisputably before she ushered EFR and his lawyer into the non-public corridor. She mentioned stairs, hoping that they would take the stairs. Didn't I say she probably wanted them to take the stairs? Well, apparently she mentioned it in the audio before they left the courtroom. That to me says, take the stairs, take the stairs, take the stairs. Without telling you to take the stairs. After that, evidence is undisputed. Judge Dugan led EFR into the non-public corridor, steered them to the right, but did she though? With her toward the public hallway and gestured emphatically that they should go in that direction. The endeavor within the meaning of 1505 and count 2 requires purposeful actions, not just words. For 18 U.S. Code 1503, this court accurately has proposed that to instruct the jury that an endeavor here requires that Judge Dugan had knowledge that her action would have the natural and probable consequences of obstructing a proceeding. In that respect, common use of the term endeavor supports a legal meaning here. They keep bringing up normal judicial powers are typical, but do they even have one other instance where she ever got up into the hallway to direct defendants out of the courtroom? I don't think so. Not that I know of. We'll see if when I get the transcripts, what the transcripts say. She did not point EFR to a stairway or to non-public exit from the floor or building. Again, this is undisputed. That falls far short of a purposeful action. There was no temporal difference between and the spatial difference was just under 12 feet. Who cares? Leaving EFR entirely within the view of awaiting federal agents, who in fact saw him just as they would have if he emerged from the main court doors. But did they though? Because the video to me looked like they were looking at the court doors and just so happened to see him. She can play Red Rover and hide and seek whenever and however she wants. Yeah. I mean, no crime because executing an administrative arrest warrant in a courthouse would violate longstanding common law privilege. We read this. She mentioned this above. Like throughout this case, the government's claim has been that executing the arrest warrant in the Milwaukee County Courthouse was a step in a pending process or pending proceeding, as it and the court tentatively defined the term broadly. The prosecution theory then is that Dugan obstructed or impeded that a pending proceeding corruptly by her acts that morning. But that is not possible as a matter of law. EFR had a pending misdemeanor case in the Milwaukee courthouse with a scheduled appearance that morning. This too is undisputed. He therefore enjoyed the privilege to come and go from his court appearance that day without execution of civil arrest warrant or a civil process. Like, she just keeps repeating the same stuff over again and expecting it to be no crime because there was no pending proceeding and none reasonably foreseeable. The defense disagrees with the court's proposed definition of pending proceeding. They wanted to put a expert on the stand to testify what a proceeding was. It's like it's up to the court to define that term, not a defense expert witness, and has tendered proposed instructions that more accurately and fairly define that term. Assuming, though, that the court does not change its proposed jury instruction on that term, the government's case still fails. Even the court's definition of pending proceeding involves all steps and stages in such an action from its inception to its conclusion. The unavoidable difficulty for the government is that action had ended. It ended in a final order of removal by an immigration judge. But wouldn't the final action be actually removing him? As to which EFR had not appealed or otherwise challenged in that final order. There no longer was any process taking place. The arrest of EFR and transporting out of the country without further process was all that remained. But isn't actually arresting him and deporting him a process? State and local officers could have arrested him for any other reason, or if EFR could have departed voluntarily himself, and the effect on any DHS process would have been exactly the same. No crime because no materiality. She already said this. Like, no crime because Judge Dugan, she just basically repeats everything she already said. Thanks for this case. Defense rests. Sweet, hold on. Let me So there's that. All right. I got it, Jeannie. Thank you so much. It really makes me angry that our judicial authorities are being allowed to inject their personal beliefs into their jobs. Laws are written and voted on by our lawmakers. Yeah, this is a legislating from the bench. And these are the people, once again, I keep saying it, but it rings true, who sit and tell you that they seem to sit on this moral high ground and are better than you because they have a higher education or they just... For all the reasons here, she explains, and those she addressed in her earlier motion to dismiss on grounds of judicial immunity and motions in limine, And in brief supporting these motions, Judge Dugan asked the court to enter a judgment of acquittal on both count 1 and count 2. No. Stephen Biskopic. Yep, you're from Thiensville. I already hate you. Yep, and then Gimbel, Riley, Guerin, and Brown. I probably will. If I ever needed a lawyer, it probably wouldn't be any of these people. So there's her motion to dismiss. So we are going to Whoa. That was weird. Share this screen. Day 5 defense rest. So we're gonna watch a little bit of this. WISN 12, I don't care.
Welcome to Carroll University.
No,
in
I don't.
Waukesha, Wisconsin.
I don't.
This is the college tour.
I don't care.
Streaming now on a screen near you.
I don't care. I don't care about Carroll University. I really don't. No offense to anybody who went to Carroll, but I don't care.
Federal trial of Milwaukee County Judge Hannah Dugan. Closing arguments are set to begin within this hour. Dugan is accused of helping an undocumented immigrant evade federal immigration agents in the county courthouse back in April. 12 News' Mallory Anderson is live inside the federal courthouse downtown. Mallory, 4 witnesses took the stand for the defense this morning before they rested their case.
Yeah, Jaron, that testimony was quick, lasting less than an hour before.
So 4 witnesses, less than an hour.
The defense rested, kicking off closing arguments, which you mentioned will start in about 45 minutes. So this podium right here behind me is being set up in anticipation of a press conference that could happen with the key players in this trial if a verdict does come down today.
And here's my thing though. Like, this is where I'm like, sometimes it's better if you just shut the fuck up. She has been making comments to the media for months. Sometimes it's just better to shut the fuck up. I'm just like, I don't know. And it was good. I'm still debating to screen in the covered back porch or not. Pros and cons. The fact that we have mosquitoes down here that are larger than my head, and the fact that we get gnats, I say screen it in. But 4 witnesses, less than an hour. Judge grudge 0 witnesses in months. I know, right?
One person noticeably missing from the defense's witness list, Judge Dugan herself. This is Dugan as she walked in for what could be her last day on trial. The defense says she's decided not to testify. Before closing arguments begin, 2 Milwaukee County judges, a Milwaukee public defender, and former Milwaukee Mayor Tom Barrett all took the stand.
Oh, talk about simping. You got Tom Barrett to... I just got nauseous. Sorry. Not like the last Sunday nauseous, but like they had the former mayor testify. I don't like that dude. I've met him in person, talked to him. I don't like that dude. Yeah, she's been throwing shit at the wall and hoping it sticks. Thought you lived in Georgia, not Pennsylvania. The summer times here kind of suck. As far as like the bugs. So, yeah.
And this morning, the 2 judges separately described the fear and confusion at the courthouse last spring as ICE activity picked up without a formal policy in place by the court system on what to do if arrests are made in
fear and confusion. How about you just let ICE do your job? If you're not here illegally, you don't have to fucking worry about it. ICE is not going to talk to, Joe Schmo from the south side of Milwaukee if they're not there illegally. If they don't have a cause to arrest them, if they don't have a warrant. Like, people think they just go around arresting everybody just because they can. And it's like, that's not how this shit works. Like, oh my God. And I just don't understand why. yeah, the Pope could testify for her, and it would not change the fact that she broke federal laws. Well, here's the other thing. The Pope, yeah, there's a Pope connection to Milwaukee too right now. So, you know, she's just throwing shit at the wall and seeing what sticks. And I'm sorry, if you have to have a former mayor testify on your behalf, you're trying to bring in the big guns and trying to intimidate federal prosecutors, and I don't really think that's going to work.
Courtrooms or public hallways. One judge even described a time in the past where she saw people, quote, snatched out of her courtroom in handcuffs for non-immigration arrests, something that she said made her uneasy with.
Yeah, and guess what? That had nothing to do with ICE. That was a separate issue, and you should have taken that up with the Milwaukee County Cop or Milwaukee PD or the Milwaukee County Sheriff's Department. That has nothing to do with ICE. They're bringing in shit that doesn't matter to try to scare this jury. And the problem is this jury is in Milwaukee. It's a very liberal area, and I don't have high hopes. But yeah, Barrett took the stand. Why? Your guess is as good as mine. You live there.
The ICE activity. Former Mayor Barrett was brought in as a character witness for the defense.
Sorry, Mayor Barrett is the last person I would want as a character witness for me. I'm just saying.
A lifelong friend of Dugan who described her as an extremely honest person who will tell you exactly how she feels.
That explains so much. So much. That right there, I can't even. He's something, all right. He's something. Bad part is he was convicted of crime. That's grounds to deport him to begin with. They need to read immigration laws. Well, he wasn't convicted of that crime. He was in there for a hearing. He had not been convicted yet. He was just in there for a hearing. So, like, I want to just, before we, like, it's not defamation per se. It is not defamation, but it's just a really bad practice in my book, and I just don't like it. Even though I don't like people, like certain people, like I probably wouldn't have been a fan of his. Let's get away from using the term like convicted criminal or convicted felon or this or that when they haven't actually been convicted yet. I get that that's a hot topic term, and and a very it hooks people in, but like, can we not, whether we like people or not, can we take that out of the equation? Calling people a felon or a criminal when they haven't been convicted yet. I call this person a criminal because he broke the law by coming here. So by definition, a criminal. But he was not convicted of a crime in the US yet. He was not convicted of like the DV stuff. Should he have probably been if he stayed here? Yeah. But we have a problem with, as a society, just coming up with these names for people, and it's like, and then you get people who don't understand the process who are now like, oh, they're a felon. It's like, not exactly. Will they be one day? Maybe. Hopefully. Probably. But like, can we get away? Because it's not legally defamation, but it's buttoned up to that line where you know that you're starting to do shit weird just to get attention, and it's just not my cup of tea. So I'm, and that had nothing to do with you per se. It was just something that I had thought about the last couple of days, and your comment just made it. I wonder how much money Dugan is getting from the Democrat Party to break federal laws and break her oath. Oh, that would be a good. Yeah, that would be a good. Yeah. Tell you what she feels is not non-biased and how judges are supposed to act. Yeah. You should never know what a judge feels.
And so, Mallory, closing arguments are now set to begin at 11:45.
Yeah, Jared.
So that was this morning. It was updated at 1:06 p.m. Eastern. So we'll see what happens for today. That is kind of all I've got for you guys today because I planned on doing this tomorrow. So we'll see. We'll see what happens. So oh look, we have the all this the Levy County stuff is actually public now. I will show you guys this tab. Jeremy. Reopened. This one. Hold on. We got to go over here for a second. Okay. I'm having to submit my requests for it. So they're not public yet. So in that anyway. And somebody sent me something. Yeah, whatever Jeremy posted is not public yet. So it's not public yet. So we will probably be going through all that tomorrow when it is public. Cuz this is what you get when you look. It's locked. And this record is available only upon request. So, and I already did it, but 101, the exhibits 102 and 103 are still locked publicly. So whatever is happening was given to the parties. So but can we refrain from, I understand that people are being referred for charges, but can we refrain from it inflaming the situation anymore and calling someone a felon when they haven't even been charged yet? When what this judge decided to do and refer to the county attorney for charges is not an official charging document. Until the prosecutor files an official charging document, he is not charged with anything. So we need to get away from that. Like, you know, I know, but he's not a felon yet. Like, he has not been charged yet. Just because the judge referred and said it's a felony is not a charge and is not a conviction. Like, there is a difference, but yet you use this inflammatory language and it gets people pissed off. And it's one of the reasons that I can understand why people don't like a certain person. Because I can just understand. It's one of the reasons that I don't name call except for Bubbles and Fleesa, is because you use that inflammatory language and it's just not a good look. It just turns people off and makes people not take someone seriously. And I know it's clickbaity, but it rides that line. It's not defamation, but it rides that line of like pissing people off, and you're pissing people off. It's not the judge referring to the county prosecutor for charges is different than actually being charged. And it will hopefully come. But remember, it took Laura Owens a year between when the judge referred to the county attorney for charges and when the county attorney actually pressed charges. So, what do you mean the prosecutor's not the one to do that? The lawyers are referred to the Florida Supreme Court for prosecution. But he's not a Florida lawyer, so it you know, we'll see. But either way, just referring someone for charges is not the same as being charged and convicted. Like, let's be clear. Like, there's a difference there. And I just get so, I wouldn't say offended, but it's just annoying because it's like you take advantage of people's stupidity. Like, you just take advantage of the fact that people don't know how to, yeah, as Jeff used to say, people be better, people try to be better. Yeah, it's like it's on both sides, but it's like you use that language knowing that people are going to start calling him a felon now. And will I think one day he will be? Hell yeah. Do I think he deserves to be? Hell yeah. But at this particular point in time, he is not. So to call him that is just it's just, I don't know, like, treat people how you want to be treated. And like, I don't know, like, we've lost, even, I understand why people in this case are very upset. However, we've lost that, like, basic human decency. Like, I just, you know, I'm just, I don't know. Maybe it's just me, and like, I try to treat people with a basic human decency and respect, even if I don't like them. Because it's what I expect people to do to me. So I'm just, like I said, maybe it's just me, but that's just my way of, and I kind of get not offended, but like, I don't know. You just take advantage of the fact that people are dumb and people will start calling him that thinking it's true. There's the problem. Because people honestly in this country don't have any fucking idea how our legal system actually works. And they start acting like they do because they heard it from this person or they heard it from this person. And it's like, you know, it's just weird. So we shall see where it goes, what'll happen. However, I just don't use inflammatory language unless I'm purposely trying to inflame. And it just weirds me out, and it rubs me the wrong way. So, like, I don't know. Y'all have a great day. Like, we'll probably talk about that tomorrow. I don't really know. But I am not the kind of person who will use language like that just for I'm not the kind of person who will use language like that just for the sake of inflaming the situation. So I will see you guys tomorrow. I have to work on some other stuff, and Mr. Squid wants to do some gaming in here. So I will see you guys tomorrow. Have a great day. Bye.